Want to know how I
like
took my
to
business to the next
you.
level? It's simple. It's
Oh, sorry,
Shopify.
guys. Yes, thank you so much for liking, sharing, and all of that, and subbing. I appreciate it. It means the world to me. I'm just getting the stream started. I just started maybe 4 minutes ago, so I'm just letting it, letting the beat build. You know what I mean?
Early in the morning, late at night.
I will be reading the document today. I'll be spending about another hour on the FOIA. And while I do that, and while I wait for people to come in, we'll just listen to some music. You said, there you go. This case is very important, in my opinion. It can change the future of our country and how autism is treated through the legal system. I agree. I definitely agree with you there. I agree with you. And I did ask a question a while back. I think it was on my poll. I'll show you guys what it ranked as. It was a while back. I asked a question relating to autism and other developmental disorders. Let's see exactly what the question was. Hang on. Okay, so this was one of the questions here. Okay, so did Nicholas Godejohn have diminished capacity? In other words, could he have pled insane? That was what I said. Okay. Okay, so 52% said yes, 33% said no, and 15% are undecided. Okay. And I also, a while back, I did a poll on, hang on, does Nick Godejohn deserve to be out of prison? Okay. Yes, 55%, no, 45%. Okay. I also did a poll. Hang on a second. I did another poll. Just trying to show you guys that poll. This was a long time ago when I did this poll, months ago. Okay, here we go. Should adults with developmental issues such as low IQ and autism be tried as adults? Yes, 40%, and no, 60%. So those were the polls that I did do. Let me show you guys. Let me bring it up here so you guys can see. Here it is right here. So as you can see, I did a poll on my channel, and I just asked, should adults with developmental issues be tried as adults? And I saw this on Reddit, which was very interesting, about a man named Joe Arity. He was a 23-year-old man with an IQ score of 46 in the mind of a 6-year-old who was wrongfully convicted and wrongfully executed in 1939. He did not understand the meaning of the gas chamber, telling the warden, no, Joe won't die. He smiled while being taken to the gas chamber. So that led me to ask, should adults, because there are adults that don't function at the level of quote unquote normal functioning adults that carry jobs and all of that, and they do have the mind of children. Should they be tried as adults? That was the question. And 60% of the people said no. So I thought that was pretty interesting. All right, so let me pull up the paperwork. If you're just coming in, make sure to hit that like button, guys. Make sure to hit the like button. We're going to be reading that FOIA. I read 91 out of 417 pages, hoping to take a good chunk out today. You have about an hour. We have about an hour with each other. Oh. Okay. All right. So let me pull this up. Okay. It's been about 10 minutes. We're going to go ahead and get started. Okay. All right. All right. I'm going to just start reading. And hey, Lindsay, how many people is it showing in here? Because on my end, it's showing one person. And I don't know if that's correct or what's going on. Is it showing one person for you? One? Okay. All right. So we're going to pick up on page 91. One on your end as well? Okay. 2. Now it's saying 2. Okay. Okay. Well, maybe the crowd is not home or available to watch the stream, but I will read. They can watch it when they get the chance. Okay. So we left off in a spot where they were talking about the people who visited Nick. Those listed in the records included Charles Goldammer, 5 visits, Stephanie Goldammer, 5 visits, Quinn Goldammer, 6 visits, Robert Godejohn, 6 visits, Richard Godejohn, 1 visit, Michael Finnegan, 1 visit. Daryl Godejohn, 1 visit. Rita Malasecki, I'm going to just say it that way, 1 visit. Rose Walters, 2 visits. David Godejohn, 1 visit. Paul Curry, 3 visits. I'm sorry, Paul Curry, 2 visits, and Michael Curry, 3 visits. These records would have given counsel the names of family members to interview as part of a mitigation investigation. So they're saying all of these people visited Nick in jail. Why didn't counsel pick some of these people to interview or to bring onto the stand to subpoena to testify as to what Nick's character was like? That's what I'm assuming they're getting at with that. They're saying you had all these people come and visit Nick. Why didn't you have any of these people that came to visit him come and speak to the judge about who Nick was? And that could have made things different. That's what I'm getting from there. Okay. They also go on to say if counsel would have investigated Mr. Godejohn's family background, he would have known that Nicholas suffered a traumatic birth. The umbilical cord was wrapped around his neck twice. Suction cups were used to assist in his birth. He looked blue when he was born, and he had to be resuscitated by medical personnel. Trial counsel would have known that Nicholas witnessed physical violence during the time that his mother was in a relationship with his father, Robert Godejohn, and that Robert Godejohn continued to be physically violent with mother, Stephanie Curry Goldhammer, even after the relationship ended. Additionally, counsel would have known that many of Stephanie Goldhammer's subsequent boyfriends after Nicholas's father were violent. Nicholas witnessed much of the violence that occurred between his mother and father, as well as between his mother and her subsequent boyfriends growing up. Okay. If counsel would have done an adequate mitigation investigation, counsel would have known that Nicholas Godejohn had a very difficult time making friends at school, and he played mostly with his cousins or other family members when he was younger. Nicholas would often be at family gatherings at his father's grandparents' home, celebrating some sort of birthday or anniversary. Nicholas got along with his cousins for the most part when he was younger, but they all knew he was different. Counsel would have known that Nicholas attended religious Catholic classes during the time he would be at his father's home, and that in those classes, he had to have special one-on-one instruction because of his disabilities, which was not the norm for those classes. If counsel would have obtained the mental health records from the county jail, counsel would have known that mental health providers at the jail indicated that Nick did not seem to know the gravity of the situation he was in, was depressed and confused. On June 17, 2015, one day after his statement to police, when asked about his concerns about his ability to cope while incarcerated, Nicholas responded that he was mainly worried about his girlfriend. Nicholas stated, "The only reason I did what I did was to be with my girlfriend." Further observations by mental health providers at jail indicate patient presents nervous, slightly confused at contact, seems very grateful to have some of the jail process explained in detail. Patient presents vulnerable and is tearful when discussing his charges. In the mental health records, it also states that on June 23rd, 2015, Mr. Godejohn stated that he's been able to read his court documents, he understands what's happening with this case, and indicated that his girlfriend was definitely a trigger for his OCD. The records also reflect that Mr. Godejohn said that he mainly gets obsessed with things, but he doesn't list compulsions. The records quote Mr. Godejohn as saying, "Before I didn't understand the severity of this situation until I had time to think." Counsel failed to adequately investigate Nicholas Godejohn's background and family history. Although counsel requested and received Mr. Godejohn's Social Security disability records, which contained some school IEP records and some limited medical records, they failed to request his mental health records and other records from the county jail where he was held for over 3 weeks after his arrest. These records and information from Nicholas's family, together with consulting a neuropsychologist who had substantial practical experience in evaluation and treating individuals with autism spectrum disorder, would have provided counsel with convincing mitigation to present the prosecutor when negotiating a plea agreement in this matter. This would have provided counsel with a way to effectively negotiate a plea agreement with a sentencing option that would have taken into consideration the considerable amount of mitigation that was present in Nick's case. Counsel was ineffective for failing to investigate mitigation in Mr. Godejohn's case and to present this mitigation to the prosecutor during plea negotiations. Counsel's failure to investigate and present this mitigation to the state during plea negotiations to get a plea offer for a sentence of less than life with parole resulted in prejudice to Nicholas Godejohn. Accordingly, Mr. Godejohn's conviction and sentences should be set aside and a new trial must be ordered. So in this part of the FOIA, they're talking about how, with the combination of Nick's medical history, his background from when he was a baby, they start talking about how he was born with an umbilical cord around his neck. They wanted Nick's counsel to do more research, in my opinion, on who Nick was, and they just feel like the counsel didn't do enough. Now, honestly, I can agree. I feel like counsel was just waiting to get the trial over with. They didn't really put a lot of thought into any of their arguments. But that also goes with saying that earlier on here, they did say that Nicholas didn't know the gravity of the situation he was in. And I do think that's true. I don't think he knew it would end with, oh, I'm in jail. I don't think he even thought jail was a risk. So that's interesting to note. He was mainly worried about Gypsy, but he did know where he was. He did want to be explained his rights. He did want to know how this jail process would go when he could get out. So he had enough sense. He had enough sense to understand that he was in jail and he wanted to know what and how could I get out. So he knew that much. I guess he just didn't, in any circumstance, think it would end with him in jail for the rest of his life. Like, he didn't see that. He couldn't see past what was going on that day, right? So, what is this? Okay, we did read this. So they believe that Nick was denied effective counsel. They believe that Nick had violation of 5th, 6th, 8th, and 14th Amendment of the United States Constitution and the Missouri. They said that Nick didn't get the right type of specialist. They wanted a neuropsychologist that specialized in Asperger's. The doctors they had on trial, none of them seemed to specialize in Asperger's. Of course, they knew about it, but it wasn't their expertise. Let's put it like that. The suppression hearing to support that Nicholas Godejohn's mental disease or defect rendered his waiver of his Miranda rights involuntarily. Okay, we start, where are we? We're here. Counsel failed to exercise the customary skill and diligence that a reasonably competent attorney would have exercised under similar circumstances. Nicholas was prejudiced as a result, and that counsel had not been effective. There is a reasonable probability that he would not have been convicted of this, and he would have not been sentenced to what he was sentenced to. Nicholas was subjected to custodial interrogation as he was subjected to questioning initiated by law enforcement officers after being taken into custody. The Miranda decision gave force to the Constitution's protection against compelled self-incrimination by establishing procedural safeguards that require police to advise criminal suspects of their rights under the 5th and 14th Amendments before commencing custodial interrogation. A heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his privilege against self-incrimination and his right to retained or appointed counsel. The government must satisfy the high standard of proof for the waiver of constitutional rights. Now, that is something that Nick didn't do. Okay? Nick did not knowingly and intelligently waive his privilege to self-incriminate himself. The police, in my opinion, this is my opinion. I'm not a psychologist. I'm not a police officer. I'm not a doctor. I'm not a lawyer, but this is just my opinion. I feel like the police used Nick's Asperger's to their advantage. They talked to Nick in a way where they seem like a friend. Nick doesn't know his rights, and she was getting Nick to sign papers. She was getting Nick to do this and do that and talking to him as if he wasn't going to get in trouble. So they did get a lot of information out of Nick because of his condition. I do feel that is true. I feel like there was he had no right to a defense in that moment because he didn't know that existed for him, in my opinion. That's how I feel about it. But some people might feel differently. They go on to say, waivers of a constitutional right must not only be voluntary, but must constitute a knowing and intelligent relinquishment or abandonment of a known right or privilege, a matter which case depends in each case upon the particular facts and circumstances surrounding that case, including the background, experience, and conduct of the accused. Okay, so they talk about Edwards versus Arizona. A valid waiver has two distinct dimensions. Moran, Burbank, these are all other court cases, I guess. First, a waiver must be voluntary in the sense that it was a product of a free and deliberate choice rather than intimidation, coercion, or deception. Okay, a free and deliberate choice. I think it was definitely deception. The police officers, when it came down to Nick, and don't get me wrong, Nick did this. Nick did it. And, you know, we acknowledge that. But when it came down to the police interrogating Nick, there was some deception involved in that, right? Second, a waiver must be made with a full awareness of both the nature of the right being abandoned and the consequences of the decision to abandon it. If you guys watched the interrogation video with Nick, the female police officer had Nick sign a piece of paper. And Nick was like, before I sign it, can you explain to me what this means? Nick kind of was like, what are you trying to get me to sign? And she was like, oh, this is just so we can talk, yada, yada, yada. Just kind of trying to mull it over when really it's something way more serious than that, right? Only if the totality of the circumstances surrounding the interrogation reveals both an uncoerced choice and the requisite level of comprehension may a court properly conclude that the Miranda rights have been waived. While a waiver of Miranda rights may be implied through the defendant's silence, coupled with an understanding of his rights and a course of conduct indicating a waiver, North Carolina versus Butler, it is not enough for the state to establish that a Miranda warning was given and that the accused made an uncoerced statement. Such a showing standing alone is insufficient to demonstrate a valid waiver of Miranda rights. The prosecution must make the additional showing that the accused fully understood these rights. In this case, counsel was aware, should have been aware prior to trial, that Nicholas was diagnosed with autism as early as second grade and with Asperger's syndrome as a teen. Counsel was aware, should have been aware, that autism spectrum disorder, and they define it for the 18th time, okay? Counsel also was aware, should have been aware, that the symptoms of ASD are present from early childhood, and they continue to talk about that, okay? In December 2015, counsel retained a clinical psychologist, Dr. Kent Franks, to evaluate Mr. Godejohn for competency. Dr. Franks found Mr. Godejohn competent to stand trial and provided trial counsel with a report to that effect, and also diagnosed Mr. Godejohn with autism spectrum disorder level 2, requiring substantial support with accompanying intellectual impairment. Dr. Frank's report was provided to trial counsel on September 28th. On October 11th, trial counsel informed the court that the defense in this case would not be NGRI, but diminished capacity. Okay. The record reflects that trial counsel filed a motion. Okay, hang on, let me read this. Okay, they spoke with Gypsy first. Nicholas had been handcuffed in a small interrogation room for at least 15 hours before Detective Mahoney began interrogating him, starting shortly after midnight. What's NGRI? I don't know. We need to look that up because I don't know. I'm about to look it up. Let's look it up. Hey, Shauna, can you guys like the stream, please? I'd appreciate it a lot. NGRI. I'm about to look that up. Not guilty by reason of insanity. Not guilty by reason of insanity. That's what NGRI is, guys. Okay. Okay, let's continue. Thank you so much, Shauna. I appreciate you so much. Thank you. Thank you. If you guys can share, like, thank you so much. I guess everyone's out partying today on Friday. Man, I'm going to make the video. I rewatched the episode today, guys. I rewatched the Life After Lockup episode and took my notes. It's because I'm filming the video after I get off live. But yeah, guys, if you're just joining, make sure to like, share. Let's get the likes up. Excuse me, y'all. Excuse me. Okay, so they're talking about Nick and how he was mistreated by the police and his attorneys and all of that. So they go on to say that Nicholas was handcuffed for 15 hours and then he was not given a blanket and he was there for 9 hours and he was wearing shorts with no shoes. I don't know where that came from. Okay. Nicholas was chattering and talking to himself, and he believed that the police were doing everything to help us. Nicholas believed the police were the good. Well, hey, let me just zip it up. Detective Mahoney had been given no information that Nicholas was autistic, and she did not glean that he might have been diminished to some degree in his capacity to understand the questions. Detective Mahoney was unaware whether Greene County has any policy on reading Miranda rights to people who have trouble understanding or interviewing someone who is autistic. She had received no training regarding encounters with people who are autistic. Nicholas told her that he was tired and that he felt loopy from being awake so long. The entirety of Nicholas's 15-hour detention was recorded on 5 DVDs that were admitted and viewed by the trial court. When defense counsel rested after calling no witnesses, trial court indicated it had 1,000 questions. The trial court pointed out that the court had no evidence of Nick's education, physical or mental condition, and no evidence of how his mental disorder affected his ability to understand the Miranda warning. Defense counsel asked the court to take notice of the November 30th, 2016 offer or proof where Dr. Franks testified about his mental evaluation of Nicholas. The trial court wanted to see the mental studies done on Nicholas by both sides. Both parties filed further suggestions, which include the mental evaluations of defense expert Dr. Franks and state Dr. Denny. Okay. The trial court overruled Nicholas's motion to suppress his police statement, and it was introduced at trial as State's Exhibit 149. Okay. Neither have experience. All right. Hang on one second, y'all. We're right here. This thing is a long ass read, y'all. She should have noticed. She should have noticed what, Lindsay? Shauna says, I got to get done by this next Friday or I lose my grade. Wait, what are you talking about? What is she talking about? I don't know. What you talking about, Shauna? What you talking about, Willis? What you talking about, Willis? So up here they say that that Nick made multiple inquiries to law enforcement if he would be able to hold Gypsy, and the officers left that door open, never answering him, which caused further distress and distraction. I can attest to that. He tells an officer, obviously, I know y'all are doing everything you can to help me and her. Okay, Nicholas replies to an officer who had inquired about his well-being. I'm just trying to hang in here emotionally since I miss Gypsy so much. Okay. Yeah, we do remember him mentioning Gypsy a lot. They're comparing Gypsy and Nick, saying that Gypsy had a couch to sleep on during the lengthy wait for the Greene County officers to arrive. Nicholas had to sit at a table the entire time. He was not given a blanket to shield himself from the cold after being in the interview room for at least 7 hours with bare feet, shorts, and a short sleeve shirt. He was bound with handcuffs for 12 hours and 53 minutes before the interrogation began. Lindsay says when he was reading the Miranda rights, he didn't seem like reading it. Wait. When he was reading the Miranda rights, he did seem like reading it. He didn't truly grasp what he was reading. He was just truly focused on Gypsy. Yeah, I agree. I don't think he truly understood it all. He was just like, I'm just ready to get back to Gypsy. When can I see Gypsy? Can I hold Gypsy? Yada, yada, yada. I don't think he really truly understood that he was giving up his right to a lawyer, that he was giving up all of those things in that one moment. So, I mean, I kind of see what they're saying here, but then again, they are kind of pushing it, in my opinion, too, because they're comparing him to Gypsy. Oh, Gypsy got a couch and he didn't. Gypsy got this and he didn't. You know, that's just lanyap to me. You need to talk about the facts. Yeah, let's read this part here. The video reflects that Corporal Maholi sought to minimize the impact of the warnings by assuring Nicholas that they were going to talk and she would tell him about Gypsy after they did the waiver first. That's correct. The context of their discussion renders it unclear as to whether Nicholas fully understood that he was being asked to waive his rights as a criminal suspect, and his statement should have been suppressed. Corporal Maholi also takes advantage of Nicholas's preoccupation about an emotional distress involving Gypsy by stating to him, if you love Gypsy, you're not going to let her get in trouble without you being there to help her. Okay. Do you want to do the right thing by Gypsy if you love her? This is the point where you're going to prove to me that you do love her when me and you talk. Yes. So she definitely used his love for Gypsy, against him to get that confession out of him. Coupled with Nicholas's impairments, the interrogation by Corporal Maholi illustrates Nicholas's inability to knowingly relinquish or abandon his rights. He had to be directed to fill out the biographical information on the Miranda form and help and instruction by Corporal Maholi. Okay. They're saying that the police officer asks if he can initial at the end of the document because there's only one signature line. His autism caused him to focus on the systematic order of the form's completion rather than on the substance of what is contained in the form itself. Okay, so I understand that. I got that. I definitely, when I watched Nick's interrogation, I kind of said the same thing when I watched his interrogation. I said, look, something's not right about this. It seems like she's easily coaxing him into the answer she wants. She's telling him that the only way he can talk to Gypsy is if he does this, or that. I see you over here, Shauna. You said exactly. Yeah. You see here. We've made it to page 100. Look at us. You made it to page 100. Yay. It's just like, when does the juicy stuff come in? This is just blah, 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 blah. Like, I could read it all. I have no issue with it, but what is this? Oh, that's way back. Okay, let me go here. Okay. They're basically saying that Nick would have testified. No, I'm sorry, that Dr. Ted Wasserman, if they would have gotten the right specialist for the case, they're saying that he would have testified that while Nicholas was provided written Miranda warnings, which were read to him, he did not have the ability to understand those rights. He would have testified that due to Nicholas's autism, he is extremely immature, vulnerable to suggestion and direction, and requires substantial support. His autism interferes with his ability to envision consequences, think ahead, or understand the gravity of the situations he is in. Okay, I agree. He would have further testified that the Missouri Miranda warnings has a Flesch-Kincaid score. I've never heard of that. Of 7.4, meaning it requires a 7th grade reading level. Nicholas's reading ability is between 5th and 6th. A neuropsychologist with substantial practical experience could have testified to the nature and extent of Nick's mental illness, combined with his well-documented comprehension deficits and the effects of being in mental distress and handcuffed for 14 hours in a small room leading up to the interrogation, and how this affected his ability to provide a valid waiver of rights. If a defendant cannot understand the nature of his rights, he cannot waive them intelligently. That's a court case that they're stating. And I don't think, truthfully, at the end of it, we know Nicholas did what he did, but truthfully, do we think he understood the nature of his rights as an accused person? Absolutely not. So that police officer took advantage of that. And that's what they're trying to explain here over like 10 pages, but that's what they're trying to explain, essentially. He wasn't in a position to understand the nature of his rights. Therefore, he can't waive his rights on his own without substantial help, right? They're saying it wasn't an intentional choice because he was not aware of the choice he made by giving up those rights. So, there we go. Are we going to Discord next? Are you in my Discord, Shauna? Sorry, when I scroll over, I can't see the comments. Are you in my Discord? You're still not in my Discord. And I don't know. I would have seen if you would have joined. You didn't join. If you're in here right now and you're new, please hit the thumbs up button, please. Where is Jay? I don't know where Jay is. I don't know where everybody is today. I came on and I did this segment. I wanted to read the FOIA because people said that they wanted to see me read it, but I mean, if you guys don't want to see it, then I don't, or maybe people will watch it after the fact. Maybe I'm just reading too far into it. I just want to give people content that they enjoy. That's all. I'm about to put the Discord link in the chat. I'm about to copy and paste it, Shauna. I mean, how long do you think it'll be? How long do you think it'll be? How long do you think it'll be, Shauna? Let me know. Because I'll switch gears. 30 to 45 minutes. Okay. Because I can switch gears. If people aren't interested in the FOIA, or if you're still interested in me reading the FOIA, let me know. Or we can do a live interview. Do you mind? Do you mind? Do you mind, Shauna? Hey, Lindsay. We're just in here. We're reading the FOIA. Like, didn't have too many people in here. I don't know if they weren't interested or what. But I can continue to read the FOIA, or we can do a live interview right here, right now. If Sean is okay with it. I don't know if she's all right with it. If she's not okay with it, then I'll get my questions together. I still need to know our topic. It won't take long. Here's the Discord. You want to do it? All right, perfect. Okay. Can you tell me the topic, Shauna? Just in one sentence, tell me what the topic is, and I'm going to invite you up, okay? You think the FOIA is interesting, Lindsay? Okay. Okay, good. Well, I will be back to it. I promise. I will be back to it. I've read 100 pages of the FOIA. What I'm going to try to do. So I read the FOIA for about 40 minutes. Let me push this up here. I read the FOIA for about 40 minutes. It was interesting. Don't get me wrong. And I am on page 101 out of 417. So we have a long way to go. We do. I don't even want to go backwards. I don't even know what to do. It just seems so daunting. Like, I don't know what I don't know what I got myself into, but we're going to get through it. We're going to get through it. Shauna said she wanted to do an interview. We can continue. If you guys want. We can continue with the FOIA. Shauna's interview. She needs to do. She has an interesting story to share with all of us. But essay and abuse. Soberly? What's that? Essay and abuse soberly? Okay. So, make sure to use, like, when you come up, just use safe words. If you can, use safe words. So I'm going to essay and abuse. And what's the third thing there, Shauna? You say and? Hold on a second. Okay, hold on a second. Sorry, guys. Yes, you can. You can make a suggestion. Go ahead. Go ahead. You are the mod. You are the supervisor. Supervisor, please make a suggestion. Supervisor. And getting sober. I didn't see that. I didn't see that. Okay. I got you. All right. So we're probably going to be canning. Well, not canning. I feel like that's a horrible way to say. We're going to be stopping at page 100. If you guys are in for a live interview, I've been telling Shauna I was going to do an interview with her. You may see it on my channel later on down the line. I have a lot of stuff to create and edit, so I'm not sure exactly when it would come up. I have a couple of questions. Yeah. Good call. Okay, so we're gonna end this one. You guys come back if you want to see the interview. Thank you so much, Lindsay. That makes it easier. I don't have to go in the back end and chop. We're about to do a live interview. You guys come back right here on the stream. All right. Good idea.